Good evening and welcome to Horizon. I'm Ted Simons. The NFL announced today that Arizona will host another Super Bowl. The league awarded Arizona the 2015 Super Bowl game. NFL voters said it was a tough choice between Arizona and Tampa. The Super Bowl could pump $500 million into the state's economy. Well, convicted Temple Buddhist murderer Jonathan Duty could soon go free. The U.S. Supreme Court today refused to reconsider a Ninth Circuit Court of Appeals ruling that threw out Duty's confession because his Miranda rights were not properly read. Duty was convicted of killing 9 people at a West Valley Buddhist temple in 1991. Here to talk about the court's decision is Gary Stewart, an experienced trial attorney and senior policy advisor at ASU's Sandra Day O'Connor College of Law. Stewart also is the author of a book that focused on the coerced confessions of early suspects in the Buddhist temple murders. Good to see you again. Thanks for joining us.
Thanks, Ted. Thanks for having me back.
For 20 years ago, real brief overview of what happened out there in the West Valley.
2 people broke into a Buddhist temple and killed 6 monks and 3 other people in an execution-style killing that shocked certainly Arizona, all of America, and most of Thailand. That was the crime.
And eventually, we had 4 suspects early, which you wrote about in detail in your book, who had coerced confessions. Once that was out of the way, we did have 2 folks that wound up being convicted for the crimes, including Jonathan Duty.
One of them was tried and convicted. The other pled guilty and was convicted. So they had a very different court process.
And Duty was the one who was tried.
Right. He was tried in 1993, in the summer of 93.
Now, what did the Ninth Circuit rule regarding a confession that was used in the trial?
They looked very carefully at Duty's confession. They listened to the audio tapes. The judges actually listened to the tapes, read the transcripts, and they decided that his confession was coerced by the interrogating officers, that it was involuntary because it was overborne. And in addition to that, they held that his Miranda rights were improperly given to him. The Miranda rights can be read on a card by a police officer in less than 30 seconds. They can be read from the official form in probably 60 seconds. It took 14 pages of transcript to explain those rights to him by the interrogating officers, and that was the most serious problem identified by the Ninth Circuit.
Was there a language problem involved?
There wasn't much of a language. He was fluent in English, but he was a Thai speaker. That was his first language. But that wasn't really a language barrier, but he was exhausted at the time. All of this took place starting at 10 o'clock, 10:15 at night, and didn't finish until 10 o'clock the following morning. So there was this long, exhaustive time period in which his will was overborne, but it began with giving him his Miranda rights, but explaining them and minimizing them. That's what the Ninth Circuit Court of Appeals held.
And the Supreme Court said, we're not going to look at this again because the Ninth got it right.
The Ninth got it right the second time, they said. They looked at this case a year ago this time, and they said that they sent it back to the Ninth Circuit and said, take a second look at this in light of another case called Florida versus Powell. And they did, came with the same result. And today the Supreme Court said, all right, you took another second look. That's all we ask. We're not going to review the case.
Now, you've seen the transcripts, you've heard the tapes. You know what went on as best as anyone could who wasn't there regarding this confession. How did he confess? How long did it take to get him to confess?
If you chart the time, and there was a really good chart made by the police officers, it took about 6 hours into his interrogation, which is in the wee hours of the morning, 4 a.m., 5 a.m. after he was arrested the prior night. Before he started, he admitted physically being at the scene of the crime. He admitted that he was there, that there were several others there, none from Tucson, all from the west side of town, and that he did not participate in the killings. He was actually outside in the parking lot at the time the killings took place. He just simply did not participate. That's his whole confession.
But so I don't understand. That doesn't sound like much of a confession.
It isn't much of a confession except under the felony murder rule. It is a confession of being physically present at a time when a brutal crime, murder in this case, came about. And so that's enough to convict him of felony murder. If the jury believes that, if they believe that came out of his mouth. They listened to it with headphones, and they read his transcript. But they only found him guilty of felony murder, not of premeditated murder.
That's why we don't see a death penalty?
Well, we don't see a death penalty because the judge decided that the death penalty was inappropriate and declined to give it at all, based on the trial, based on the evidence, and based on the judgment of the trial judge.
So what happens now? The county prosecutor is refiled? Is this? I can't imagine they're just going to let him walk free.
Well, there are some housekeeping details. The case goes physically back to the Ninth Circuit. The Ninth Circuit prepares some new documents, sends it down to the U.S. District Court here in Arizona, and the District Court has orders to either release Jonathan Duty or allow the state to retry him. So the ball will really fall in the Maricopa County Attorney's office. They will make a decision about whether or not to retry Jonathan Duty. It's likely that they will make an affirmative decision and start that process of preparing a new trial for Jonathan Duty.
And that means getting his accomplice, this Alessandro Garcia, I believe his name was, who helped with the prosecution last time, to help again. Now, this guy is obviously put away forever. Is he going to help again?
Well, that's one of the biggest questions to be answered. The terms of his plea deal probably obligate him to testify again, or they could try to use his trial testimony. They've got that as a matter of record. But he may say, sure, I'd like to come back to Phoenix. He may not say. No one knows. So that's a big problem for the prosecutor. But the bigger problem is, if that's the only evidence against him, because his confession is now inadmissible.
Right.
There's no forensic evidence of any kind to place him at the crime scene. So if somebody physically has to put him in that room, and it's not going to come from him this time. Last time it did, but this time somebody else has to do that. The only person that can do that is Garcia. And so Garcia may agree, he may disagree. So that's a big, giant question as to whether or not the retrial will be successful. There's lots of other questions, but they've got to start with that one.
So when Duty's attorney says that this confession, which now is inadmissible, just forget about it, doesn't exist, when they say that confession is the cornerstone of the prosecution's case, they may have a point.
They have a big point, because that was the cornerstone. The only other evidence that puts him at the scene is by Alex Garcia. There's no other evidence.
You've written, and we talked about your book last time you were on the program, about coerced confessions, mostly about the Tucson Four, who were originally confessing to this crime and had absolutely nothing to do with it. When you hear about this confession under these circumstances, surprise you at all?
No. If you read the Ninth Circuit's opinion, they start out on the first page of their opinion. It's a long opinion, 106 pages. They start out with what happened in Tucson. And they remind the readers of the opinion that the same team of investigators that took these false confessions and coerced them also took these purportedly true confessions and coerced at least one of those. They've never looked at Garcia's confession. So now every confession they've looked at, they have found to be coerced by the interrogators and not given voluntarily by the suspects. So it doesn't surprise me, after having read the transcripts and listened to the audio tapes. Frankly, nor does it anyone else, at least as to the first group.
All right. Well, fascinating stuff. It's good to have you on the show. Good to see you again. Thanks for joining us.
Nice to see you. Thanks, Ted. Bye-bye.